And to move to the second section of our discussion, namely the expert forum, to introduce the first speaker, I think we can definitely rely on the fact that the Corruption Prevention and Combating Office really has a lot of experience. They have been very committed in developing as a lobbying framework in Latvia. I also have to note that CNAB coordinates the compliance with the contractual relations, contractual liabilities of Latvia under Greco agreement. Thus, I'm very interested in what Aļošina can tell about the CNAB experience, ideas, maybe some things that we have to focus on in the process of development. So Anna Aļošina from the Corruption Prevention and Combating Bureau, head of the first strategy department. Please, the floor goes to you. Thank you, Inese. From my side and from on the behalf of the Bureau, and in particular on behalf of Jakob Stram, the head of our Bureau, I would like to express our gratitude for the possibility to participate, to share our experiences, ideas. And we would like to say a huge thank you, because we knew how difficult it was to develop this law, at least in our body. And due to this, we are very committed to share our experience. And I can confirm that this is one of the steps how we can really reduce corruption, corruption in Latvia. In particular, when we consider the fact how decisions are made, if it's hidden or somehow obstructed, or then there is a suspicion about corruption, though corruption may not have materialized. Thus, it is very important that we have this draft law, and we are one of the parties that could show that we can also have a draft law that would apply not only to professional lobbying that takes place in many countries. We are working on a law that would be much wider and would be applicable also to groups that are not professional lobbyists, those that do not make any. As a result, we also developed a draft law that actually revealed many problems, many obstacles and objections from bodies and also NGOs. And my purpose is to share, to demonstrate the challenges that we would like to warn you about, but at the same time, we are also ready to contribute or to make our contribution to rectify these deficiencies so that the draft law could materialize. So the first challenge and conclusion was that when we worked on the draft law, we understood that the lobbying process as such, it's basically a part of the public engagement, public participation. It's like a function. Thus, it was very problematic to draw this line between what is interest representation and what is public involvement, public participation. Are these two equivalent processes or two different processes? So in the traditional understanding, what is lobbying? Is it interest representation? Is it what it is it's someone's communication, direct or indirect, with public officials or public bodies to affect specific decisions, so that these decisions would differ, so the draft laws content-wise would differ. And that's a classical traditional understanding. But we also established that actually many elements of lobbying or interest representation have already been included in our laws. Let's say a traditional example that international experts have also found quite well established is that these processes are quite well established at the government level and also at the municipal level. If someone, let's say, these consultation processes, and if someone drafts a law or some other document, then you have to ask for public opinion. You have to organize a public consultation, and there's a specific deadline by which the public should be given a possibility to express its opinion. And there's also an obligation not only to receive these recommendations, but also to disclose who has submitted a specific proposal, which proposals a lobbyist or a specific group of people, and so on, was submitted, and what was the outcome, whether it was taken into account or not taken into account. Also, the bodies are obliged to review these comments and provide an answer, substantial answer, if the proposal has not been taken into account. So these participation mechanisms at the governmental level are quite strong. Maybe you have more problems, and Inese already mentioned this, and it was also mentioned by the speakers. Namely, currently our weakest link is the parliament. An example, at the parliamentary level, if an MP submits a proposal on a draft law, he or she is not obliged he's not obliged to disclose with which formal or informal groups he has or she has communicated. As far as I know, the sign has already still that maybe not the MP who has prepared the amendment or the proposal, him or herself, but some third party whom no one knows. And that creates this lack of trust in the parliament. The first problem was to separate lobbying processes from public participation processes. We also saw that there are several laws that already duplicate many obligations that public officials would have if the lobbying framework would be introduced. And I think the greatest lack of understanding, and we could not give an answer ourselves as well, how to delineate someone who submits an application in the meaning of the law from someone who's actually lobbying. So if someone like a physical person, an individual, submits an application, relies on his or her constitutional right to submit submissions like applications with proposals to public bodies, would that be considered lobbying? Though this proposal could contain and could have this underlying aim to affect a specific draft law. So it was very difficult because we did not have these very clear borders, because this application mechanism partially, and here I would like to underline the word partially, overlaps the lobbying framework. But the invisible part is that this application maybe is not made public. So partially the elements were already in place. Also, here we should speak about the prevention of conflict of interest law, and there was some specific overlapping elements as well. For example, public officials have an obligation to inform a high official if this person or his or her relative or business partner is interested or is approached with regards to specific decisions, because these people are not allowed to participate in the decision making. We also had a dispute about the following: whether the political decisions that the lobbyists try to affect, should they be included in the exceptions? These political decisions that are made, or these political directions of political parties, and if they are approached by lobbyists, then would the lobbying framework apply to such cases or not? We also had problems with expert opinions. So what does it mean? Let's say some time ago, we had a discussion let's say if a body approaches an association that could provide its expert opinion, and this association, let's say like a builders association, provides its opinion, would that be considered a case of lobbying, an attempted lobbying that should be disclosed to the public? So far, we haven't found a definite answer. Maybe yes. My personal opinion would be yes, because such opinions could contain certain elements of lobbying that would affect the final result. There were also questions about what is a lobbyist. And here we have to make this choice that I mentioned at the beginning. If Latvia chooses to regulate not only professional lobbying, let's say associations that make money with these activities, but if we also regulate, let's say, public wish or specific members of the public wish to express their opinion, then we need to ask, what is a lobbyist? Is a lobbyist just someone in the first meaning of this word, or maybe the lobbyist is also for whose benefit the lobbying takes place? There was also an unanswered question, namely whether in cases, let's say if we have a company who is engaged in lobbying or contacts a specific public official or a body, is this company considered a lobbyist? Or indirectly or even directly, also the shareholders would be considered lobbyists and beneficial owners maybe. So the definition of the lobbyist will also need reconsideration. Namely, we will have to decide how extensive it is going to be and who will have these duties and obligations and limitations. The next obstacle that we saw a few years ago, that became topical a few years ago, namely to ensure real openness in the case of interest representation. We had to think about how we will disclose identity or data of the lobbyist. Most probably it will not be problematic to disclose like foundations, associations, legal bodies, and so on, because they are not subject to the personal data protection law and also the GDPR regulation that applies to protection of personal data of individuals. So even if we physically have to disclose a person's name and surname, will that be enough to identify a specific person, a specific lobbyist? The next thing, or maybe potential question, is whether a contract is needed between the lobbyist and someone for whom the lobbying takes place. Of course, certain exceptions are allowed, like associations, for example, when according to the articles of associations, an association represents its members, so maybe a legal document is not needed. And then we also have to think about the purpose of this written contract, what we would achieve if there was an agreement, a contract between the lobbyist and someone for whose benefit lobbying takes place, and whether this contract should be entered in a specific register to confirm its existence. We also discussed with all the stakeholders the form of the actual lobbying, whether lobbying is only written communication, oral communication, or lobbying also includes social media communication, because social networks public officials can be approached via these social networks. They are public, everyone knows about them, but would that be considered lobbying activity? The same applies to media, because media also can have representatives of media, can have a specific interest in specific laws. So maybe some laws that affect mass media, like a mass media law or specific regulation. So maybe the articles could be considered lobbying in this case. That was another matter that we discussed. Also, one of the largest problems was related to the administrative burden and information disclosure in the interest of the society. First, whether the disclosure of information should be ensured by both parties. The lobbyist should inform about the fact that he or she has contacted this particular public official, and whether this disclosure obligation should be placed only on the shoulders of public officials and public bodies. Some time ago, we had a plan that what concerns members of the parliament. And here we should remember that the MPs have a right and an obligation to communicate with their voters. But we saw also that if, as a result of this cooperation, a proposal is submitted, then disclosure of this effect only when the decision has already been made, that could be problematic. Of course, this requires a political decision, and of course we don't want to instigate any suspicions that certain decisions are made behind closed doors and no one knows about that. But if as a result of this cooperation a specific decision is made that affects a law or a draft laws, and maybe then it should be made public. The next painful question was the register of lobbyists. We have to understand for what purpose we want to create such a register. If it's made only to disclose professional lobbying activities, then there shouldn't be any problems, because the Latvian Confederation of Employers, that is a classic lobbyist, as well as the trade and trade chamber that represents merchants, these bodies will have no problems to disclose their activities and register with this register. Or we plan also to include physical persons, individuals in this register, especially those who submit specific applications that result in proposals or changes to the law. Also, we have to remember that what concerns the register, we have to decide whether it's going to be a register that only lists physical or legal persons who are lobbying, or it is going to be a register that will also disclose, a centralized register that will disclose all lobbying activities. And here we have to remember that it is also financially intensive. Such uniform register requires funds. But this is also the aspect that we will have to think about. We also faced the following. Lobbyists made the following objections. They concerned the process internally in the company, in the organization, because there are associations that represent not only one group of persons, but several such groups. Let's say there are associations that represent micro companies or larger companies that export their products. And also what concerns lobbyists, they have indicated that it is very important for them to avoid situations when only one group is represented. So it's a matter of internal organization, I believe, but this is something that the lobbyists would like to sort out, that there could be maybe some self-regulation mechanisms, and maybe the state could get engaged. They would like to see this self-regulation mechanism because they don't want to face a situation when only one group of the entire organization is represented or benefits. I believe briefly that was it from my side. I would like to wish to the working group to have this draft law ready and move forward. Of course, there was also a question about the supervision mechanisms. That was, so to say, a painful question for us as well. How to make the interest representation openness law feasible, applicable in practice, and also verifiable, so that there are no persons or groups that are engaged in lobbying, but no one knows about that. Thus, from my side, I would like to wish the working group great success. I believe many problems have already been solved, but if not, these will definitely be the problems that you will have to face. And as always, our bureau will always provide our support, our knowledge, on how to solve these issues better in a proportionate manner for both parties, both for the state administration and lobbyists. Thank you. From my side, that's all.
Thank you very much to Anna Aļošina from CNAB for such a comprehensive list of possible issues for the discussion. And it is very valuable that we have this transfer of knowledge, this previous experience towards the current work. And I guess that representatives from the parliament have already reactions, and they would be ready to answer the questions, some questions asked by Anna, but we will spare it for the second part, for the discussion, which will be led by Sergejs Moravjovs, who is Transparency International Lithuanian chapter representative or the head of this institution. And in continuation, we would like to ask Mr. Rasche to share about his experience. So he has experience from the point of OSCE, Office for Democracy, Institutions and Human Rights, and so how this aspect is so important in this international arena. Why and what does it give to the political systems internally? So what are the main principles we have to include in this regulation to guarantee the democratic principles we are talking about in this context?
Well, thank you very much, Inese, for this for this introduction. And let me just see if I have all technical aspects. Yes, everything is fine. So warm greetings from Warsaw, from a gloomy afternoon, from OSCE Office for Democratic Institutions and Human Rights. I would really like to start with thanking the DELNA for convening this event, and to extend really appreciation to the Embassy of the United States for supporting such an important event on this topic. We are having a very, how to say, a good record of a great cooperation with Latvian institutions, to start with the Parliament, with the CNAB, and also our colleagues from the civil society from DELNA. And this event and our participation is just the continuation in that direction. I really enjoyed listening to a colleague from CNAB who really raised already many questions and dilemmas that are posed to those who are developing the law, and also want to share that we are in a constant communication with Ms. Inese Vojka, who I also extend the greetings from our office this time as well, the chair of the working group on developing this important law. And what I would like to stress out at this point is just a few basic aspects to keep in mind when regulating lobbying in Latvia and elsewhere, and also what is seen as main challenges in that respect. As it was mentioned by some of the previous speakers, lobbying, the way we see it, should be looked as a fundamental aspect of democracy. When you have lobbying regulated, you have to look into political pluralism. Lobbying is about decision makers. It's about those who are making regulations. Although the regulation is applied to people from mainly corporate businesses, but the way we see lobbying regulated is how to regulate the interaction between these subjects and the decision makers, which are mainly political institutions of every country. When doing that, you also have to keep in mind to protect freedom of speech and expression, which in certain ways with regulating lobbying would have to be, someone would say, limited, but mainly the way we see it is it would have to be regulated. And why so? To avoid the perception that there is a biased decision-making process, that there is a capture of state by different policies or influencers, and also that there is foreign influence that also should be prevented in any modern state. Also, another important aspect, the way we see it, is the lobbying is a part of a larger national integrity system. So lobbying alone would not have its impact and what aims to be achieved with this regulation if it is not a part of a comprehensive integrity system that regulates political party finances, both in the terms of regular work of political parties, but also in the campaigns. The other aspect, also important one, the regulation of public procurement, so that the public and everybody interested could see what is the relation between publicly procured goods and those who are influencing decision makers. The conflict of interest is another part of a larger national integrity system that should be in place so that lobbying should contribute to this regulation and to basically avoid conflict of interests. And also the rules on what colleagues from OECD call revolving door, the post-employment rules, the rules that are in place for any public official that are determining in which period after they end their public official positions they could engage in certain corporate businesses or any other allowed activity. The third way that we see lobbying as a part of something bigger is the lobbying is and should be looked as a way to raise transparency of parliaments. So when we speak about the lobbying as a fundamental aspect of democracy, in every democracy, and in Latvia as a parliamentary democracy, parliament being the supreme body, legislative body, the most important aspect of regulation is basically to raise transparency of parliaments and those who are sitting in them, because all this lobbying should be regulated to have a proper view on agendas and public consultations between parliamentarians and different influential groups and anyone who has a say in developing certain regulations. The other important aspect of raising transparency of parliaments is also to look into legislative footprint, so to have a very clear path available for anyone to see what was who was influencing the process, from where the ideas and amendments were coming, the different proposals and drafts, and who stands behind. And the last point, when it comes to raising transparency of parliaments, is also something that we are very much involved in, and that is the regulation of codes of conduct for MPs. In different countries, you have different mechanisms like integrity officers who are helping the parliamentarians to understand what they can and what they cannot do, what is considered as unethical behavior and not compatible with the role that they are doing. So all of this should be kept in mind when regulating lobbying. And just to mention a few challenges, and I would say it goes well after the presentation of the colleague from CNAB, and that is about, for example, what should be the scope of the law regulating lobbying. And when we look at it, and also based on the experience of other countries and the very valuable evaluations from the Greco, we would say there are three major questions that should be answered with this defining the scope of the law. And this is, first of all, who should be the subject of that regulation. So in some examples, countries, you have only consultant lobbyists, somewhere in-house lobbyists. In some countries, you have NGOs also part of those registers. We know, for example, in Poland and in Lithuania that NGOs are excluded. So there are different solutions, but what is definitely a recommendation is that this should be clearly defined in the law. So also, what is considered lobbying? One of the definitions that any direct or indirect communication with public officials, political decision makers, or representatives for the purposes of influencing public decision making, which is carried out by or on behalf of any organized group. So it can be oral, it can be written communication, electronic in nowadays. All of this should be also defined in the law. And the last part of this definition should also include how often these kind of reporting should be made. And in that sense as well, there are various experiences. Somewhere it's once a year, somewhere on several occasions throughout the year, 3 times or so. In some cases, it's obliged to report immediately as the lobbying activity has been happening. So these things should be looked at and clearly defined, whichever way you decide to go, but that basically definition is definitely needed so that those who are going to be subject of this law will know exactly, and that there will not be room for misinterpretation of the regulation. The other challenge for regulating properly the lobbying is to make sure that you have an effective oversight and proportionate sanctions. When we say effective oversight, there are also different solutions. In some countries, it is one national body, anti-corruption body, that deals with that. Somewhere else, this oversight is divided between 2 or more institutions. When that is the case, the most important aspect is that there is a clear delineation of authority between these institutions, and moreover, that there is a clear and effective communication and coordination between them, so to make sure that the regulation in place is properly introduced and implemented. The range of sanctions also vary, but I wouldn't like to speak about sanctions. I would more like to speak about the public awareness and to make sure that when you are bringing the law of this kind, to invest in awareness raising and a cultural change, because usually lobbying is seen as something bad, something behind the scenes. And with this kind of regulation, you avoid such stereotypes, and actually events like this one we are having today is actually, that's a good example how you build up the trust and awareness and understanding of a need to regulate something that has been existing ever since the humanity started, that humans started to exchange among themselves. So awareness raising can have different forms. You develop a code of conduct for officials. You can also form the advisory bodies that will be there to help anyone who is interested in to interpret the rules and regulations. The various trainings and materials to be disseminated and organized for all sides involved in the process. The public campaign to raise awareness among those who are looking into the activities of the parliament, and also to promote good practices, because usually when people see that someone else is doing it somewhere else and it is being welcomed, then it is also easier for anyone else to accept that it is something needed in your own country. And maybe to finish here with the ways that we as an office can assist in any of these aspects, and that I'm aware that colleagues from Delna know it very well, also the esteemed colleagues, partners from the Latvian parliament, that we are already in touch. But just to name shortly the few major aspects that we can offer, and that is to produce a legal opinion. When you develop the draft law, you can always send us a request, and as a parliament or any other body, institution of the country, CNAB, that we will be able to get international experts and get this legal opinion also from our in-house expertise on the draft, and also later on the adopted legislation. We can also organize and facilitate exchange of practices, as I mentioned, as one of the aspects of raising awareness. In the time outside of pandemics, usually we are organizing study visits for members of parliaments to other countries where certain legislation has been adopted, to exchange in practice what were the challenges and how the implementation goes. But in these times of a virtual reality, we are now mainly focusing on the virtual roundtables, and let's hope that soon we can go back to regular in-person exchanges. We can also assist with trainings of the staff, of designing the regulations. There are different aspects and of this engagement that we've been doing with several OSCE participating states, and the last one also being the review of the Parliament's Code of Conduct as an important aspect of the whole comprehensive integral part of the public integrity, and that lobbying regulation of lobbying should just be a part of. I hope I didn't take too much time. I'm happy to leave more space for questions afterwards. And once again, just to thank dear colleagues from Delna for organizing this, and the esteemed Embassy of the United States for supporting such an important event. Thank you very much, and wish all the fruitful discussion afterwards.
Thank you very much, Josh. Thank
you very much to our colleague. Maybe one thing we can take very quickly to build the bridge to the next speaker is that this regulation is also related to the change of culture, that lobbying is not bad. And I would like to remind the story about whistleblowing. As soon as the law was adopted, in the public, everybody was saying, oh, this is that you are reporting on somebody else. You are telling bad things about other people. But it was in the beginning. But now the culture has changed and people have a totally different opinion. And let us understand also it in relation to the lobbying and about experience of one country, experience of the US, what has changed, and what changed after adopting this regulation on lobbying. So we have invited the senior counsel on global anti-corruption from the US Department of Justice.
Such an early morning for you, but the afternoon for us. So, Peter,
thank you so much. I really want to thank the organizers of this event, as well as the speakers so far, and the speakers to follow as also. I want to thank them primarily for getting me out of bed early in the morning. I'm addressing you from the United States, from Washington, D.C., and the sun is almost up. So let me start by just making something very clear, and that is that I am not really an expert on lobbying, okay? I am and have been for many, many years a public corruption prosecutor. Like Amit, who some of you know, I work on the federal level in the United States, and what we do is focus specifically and only on corruption cases in the United States, domestic corruption. Unlike Amit, I am not, I don't have a jurisdiction throughout the United States. Our cases are handled, and we typically work with the FBI on these corruption matters. I have investigated and prosecuted judges, legislators, governors, and yes, lobbyists. And while prosecuting lobbyists, and we'll get to a big case in just a moment, but I have actually learned a few lessons that I'd like to share with you. These are strictly my opinions, but they're also born of observations about the role of lobbying, or as you call it, the representation of interests, which is probably a cleaned up word or name, but a few truths that I think that we have already been underlined and will be also emphasized throughout the day, which is that lobbyists perform a critical function in democratic society. I think there's no denying of that. As your law points out in the title itself, what we call lobbyists are people who indeed represent interests, and interests need to be represented. That is the substance of democracy. Some of these interests perhaps are nefarious and bad. Some of them are very good, but the important point is they need to be debated in an open and transparent way in order for democracy to flourish and to remain viable. I've also come to appreciate, and this is important, I think, that the rules must be the same for everyone. That in fact, they ought to apply to the for-profit world as well as the not-for-profit world. They ought to apply to civil society as well as business and private interests. Why is that? Well, the first probably obvious point is that they need to be uniform and applied uniformly and enforced uniformly, because we have all seen how organizations and people who claim to be operating under a nonprofit ethos, in fact, have been captured or actually created by people who have a very private interest. And so that's, I think, obvious in our society, in our culture, and certainly throughout Europe, including probably Latvia as well. The second one is, and maybe even more important, is who's going to decide? Who's going to decide what's good? Who's going to decide what's bad? Do we really want to entrust that particular function to a person or an entity within government? And I think the answer is probably no. Certainly my answer is no. But the third important thing that I have noticed in working these lobbyist cases from a criminal enforcement perspective is that lobbying or interest representation is going to happen regardless of your rules, is going to happen regardless of your laws, is going to happen regardless of your administrative or civil laws, is going to happen regardless of your criminal laws. It's just a part of human nature, as our colleague pointed out just a few minutes ago. I grew up in Chicago. Chicago is, you probably know this expression, maybe not, but Chicago years ago when I was growing up, and I won't tell you when that was, but years ago, it used to be a city where decisions were made in what we call smoke-filled rooms. Rooms where, and these were typically in the back of taverns or bars or maybe restaurants. And these were rooms that were closed to the public. They were sealed off, no windows, only one door. And they were rooms with lots of cigar smoke. And men, very often big men, overweight men who were smoking cigars would make important decisions that affected everybody outside of that room. And they would make them not based upon a public debate, not based upon a transparent discussion, but based upon private interests. And so the point here is that it's going to happen, and don't we, as societies, want this to happen out in the public rather than in the smoke-filled room, which is, these are simply the observations that I've made in working on a case, and it actually involves a fellow by the name of Jack Abramoff. Now, I don't especially think that Abramoff is of great interest to you. It was a fascinating case. It absolutely consumed us for years within my office in the Department of Justice. But it was, and my office, by the way, and some of you historians out there will find this interesting. My office was created in the wake of the Watergate scandal in the United States, and it was created in order to tackle big corruption cases. And over the years, that's what we've strived to do. But back to Jack. Jack Abramoff was a lobbyist. He was a big lobbyist in the United States in Washington, D.C. And he made lots of money and he represented lots of interests. He was investigated by us and FBI agents. He was convicted. He was sentenced. He went to jail, and he went to jail for bribing legislators. He went to jail for bribing executive branch officials, and he went to jail not for breaking lobbying rules, but in fact for violating corruption of laws and statutes. And he went to jail for a long time. If you want to know more about Jack, I have I have one recommendation, and I have one more piece of information that may be of interest. There's a good movie, and there's a movie that's perhaps not so good that have been made about Jack Abramoff. The good movie was directed by a very esteemed and recognized documentary filmmaker named Alex Gibney. I'm not saying this just because I went to college with Gibney's brother, but I did happen to. But the point is that it's a good movie about Jack and about the scandal that surrounded this lobbying scheme. In fact, I would say it's a movie about the scandal that surrounded the corruption scheme. But nevertheless, that's the good one. The one that hasn't been recognized so much stars Kevin Spacey. It's a Hollywood potboiler. And if you're perhaps looking for something during the boring pandemic times that we're all living through, that might be the more interesting one. It's called Casino Jack. But the point of the matter is that Casino Jack was Jack Abramoff, who made an absolute fortune in lobbying in Washington, D.C. At the time, and this was a few years ago, in the United States, we had a set of rules, of regulations that applied to lobbyists. We had rules that, for example, required lobbyists or said that lobbyists could not enter into conflicts of interest, could not represent to clients that in fact had conflicting interests. That seems to be a pretty fundamental and simple rule. It was on the books at the time. We also had a rule about gifts, that lobbyists couldn't give legislators and others that they wanted official acts from, decisions from. They couldn't give them gifts, or at least could not, they had to be disclosed. And that seems pretty fundamental too, right? The rules, unfortunately, were not enforced. But the story of Jack Abramoff, importantly, involves those rules. Because, but for the fact that we had these rules on the books, Abramoff probably would still be lobbying in Washington, D.C. Why do I say that? Well, somebody caught wind of the fact that Abramoff did have conflicting interests. He represented two different clients who had both wanted the same thing. And that was noticed. It was publicized. The legislature held hearings. Oversight was part of the story, and in fact, it led us to look at the newspaper, to hear the hearings and the testimony, and to say, "Hey, I think there may be a criminal case here. I think we should, at very least, get some FBI agents and some prosecutors assigned to work this case to see whether there's not a corruption case." The point is, had we not had the rules, we would not have had the allegation to take the next step on in the criminal matter. The gift rules, same way. It turns out that what Jack was doing was taking legislators and others on lavish trips to Scotland to go golfing, to go bring the wives to go shopping, all expense paid, all of it paid by Jack. And in fact, what we learned, what came out during the criminal prosecution, is that in fact, Jack was arranging for the disclosure statements to be lies, to be fibs, to say it was being paid by somebody else, not by Jack Abramoff, who had clients who had interests that could benefit from these public officials. So the rules accomplished one thing. They may not have been enforced, but they accomplished something, which is that they led directly to the discovery of this criminal case. Now, should a country simply impose administrative rules in order to sit back and perhaps hope that a criminal investigation grows out of the violation of those rules? Probably not. Probably would have been much better. And many commentators in the United States have said it would have been much better to enforce these rules because it has a preventative factor, function. In fact, it leads lobbyists who may not otherwise be inclined to follow the rules because somebody's watching. But the point is, because we had the rules, it led to the discovery of the criminal behavior. And so that is one important function of having a framework, having an administrative architecture in place to force these things into the public, because into the sunlight, out of the smoke-filled room, because that's our goal here, right? So ultimately, but for the administrative rules, but for the fact that people discovered these violations of the rules, we would not have had this this great big case. And the case did. I'm not underestimating or overplaying. I'm not overestimating this. It did have a big impact. What it did was, and again, it was a big case. We had 50 FBI agents. We had eventually 20 convictions or so. A lot of people ended up going to jail or otherwise being convicted of serious corruption felonies. But once the chips settled, once the press began to, and policymakers began to view what had happened, and once Congress changed its composition, we ended up with a new act, a new and more stringent statute that is called the Honest Leadership and Open Government Act, and that grew out of the scandal of the Abramoff, and it gave us a lot more provisions to be able to control and otherwise to pay attention to what's going on in the lobbying world. It introduced electronic filing of lobby disclosures so that they're publicly available and they're in a searchable database. It required more frequent filings on the part of lobbyists. It required more information and restricted the gifts like the trips to Scotland and things like that. And importantly, in the United States, perhaps not so much in Latvia, but it required a tying of campaign fundraising, which lobbyists have been engaged in for many years, required that to be disclosed. And so we do have a stronger framework now. Some have said it's not strong enough. Some are saying that it's not being enforced. But the important thing is that it is pushing us in the right direction, which is sunlight, exposure, transparency, getting out of the smoke-filled room and back into the public forum where these kinds of debates, these kinds of attempts to represent interests need to be located. It's not perfect, but this is important because it's important for you, it's important for every country that takes on these tasks. It's never going to be perfect at first, nor will it be perfect 10 years down the line or 20 or 30. It requires us to be vigilant. It requires us to constantly question what, in fact, we're trying to accomplish and how can we do it better. Here, luckily, unlike some policy areas, here it's pretty straightforward. What we're trying to accomplish is transparency in governance. We're trying to accomplish bringing these issues out of smoke-filled rooms and into the public sphere of discussion. So small steps, but all leading away from Chicago in the several decades ago and toward a more transparent society. And ultimately, if some people have to go to jail, that has to happen. But ultimately, this framework will grow out of those kinds of things, but also assist the law enforcement community in your country to discover the corruption within the larger lobbying unit. So it's not a question really of should we have an administrative framework or should we simply rely upon our quite competent prosecutors and judges and our quite effective criminal corruption statutes. One goes with the other. It's hand in glove. It's very important. Like so many preventive measures, it leads to the discovery of the problems within a certain area. It leads to the discovery of criminal wrongdoing. And that's, I think, the goal is to create institutions that actually complement each other. And sometimes that works, sometimes not, but we have to keep trying. So thank you so much for your attention. Very, very best of luck to you today. It's not an easy topic. All of these various issues that you'll be debating and talking about are important ones. But again, it's important to realize changes will come in the future, because you're never going to get it perfect and right at the outset. So thanks for your attention. I do hope that this was helpful, and I remain with you for questions or comments. I have no problem if you want to tell me that you don't agree with anything I said, because I've been told that before. Thanks very much.
Very much for putting lobbying for us and maybe a little bit different context, and also for questioning again the question about do we have to use the word lobbying or representation of interest. Mūsu laiks šai pirmajai sesijai.
I believe that time is up for the first session, and we would like to use an opportunity to have a 5-minute break. But if you are following us on Zoom and if you have any questions, please use chat to send in your questions. But otherwise, now we will have a short 5-minute break, maybe to let some fresh air into your rooms, and then let us resume in 5 minutes, who will be moderated by Sergejus Muravjovas, Transparency International Lithuania Director. And we will have several panelists, Inese Vojka, Laura Sansleki, Inese Pušča from the State Chancery, and others. Thank you.